10 things to do before litigation. Litigation is expensive, stressful, and time-consuming. But if you prepare properly before it starts, you can save yourself a ton of headaches, money, and even improve your chance of winning. Today, we are diving into a topic that can make or break your case. That is, 10 crucial things you need to do before litigation begins. Whether you are thinking about suing someone or being sued, these steps will give you an advantage before anyone steps into a courtroom. Let's get started. Firstly, define your goal. Understand what a win looks like. Take Sarah, for example. She wanted to sue her ex-business partner. When I asked her what a win meant, she said, "I just want justice." Sounds good, right? But that's not a legal goal. Once we talk it through, we define it clearly. She wanted $50,000 in paid profits and a signed agreement that her former partner would stop using her brand. That clear definition changed everything. Her legal strategy, her negotiation approach, even her mindset. Before you go to court, ask yourself, why are you considering litigation in the first place? What do I actually want out of this? Is it about recovering money you earned? Whether it's about enforcing a contract, protecting your reputation, or stopping someone from doing something. Litigation isn't one size fits all. What winning looks like depends entirely on what you want out of the process. Here's what I tell my clients. If you can define your ideal outcome in one clear sentence, you are ready to move forward. If you can't, you need to pause and think more deeply. And remember, a win isn't just always about crushing the other side. Sometimes it's about reaching a fair settlement, preserving a business relationship, or simply getting a closure. The clearer you are about your end goal, the more focused and effective your entire legal strategy will be. Second, plan your budget. Now that you know what a win looks like, let's talk about the reality most people underestimate, the cost. Here's a true story. A small company sued a supplier for $20,000. After 2 years of litigation, they won, but they spent over $30,000 on legal fees. They were right, but they lost financially. Litigation is expensive, not just in legal fees, but also in filing costs, expert witnesses, discovery expenses, and lost time from work. I always recommend creating a realistic budget before you begin, just like a business plan. Ask yourself, how much are you willing and able to spend? What's the maximum limit? How much might it cost if it goes all the way to trial? Is the potential outcome worth that investment? Knowing your financial limits upfront helps you make strategic choices later. And don't forget hidden costs, time away from work, stress, and opportunity loss. If the math doesn't add up, maybe litigation isn't the right path, or maybe settlement makes more sense. It's better to know that now before you are deep into the process than to realize it after spending thousands. So plan your budget carefully, building a cushion for surprises, and make sure your definition of winning aligns with the financial reality. Number 3, manage your time and check the statutory deadline. Money isn't the only resource litigation consumes. Time is just as important. Lawsuits can take months, often years. And during that time, you will need to attend meetings, respond to discovery requests, prepare evidence, and possibly appear in court. Look at your schedule realistically. Do you have major work projects ahead? Any family commitments, vacations, or travel planned? Make sure you can commit the time this process will require. And while we are talking about time, here's something absolutely critical: the statutory limitations. Every type of claim has a deadline. If you miss it, your case can be thrown out of window no matter how strong it is. So before anything else, check your timeline. Are you within the legal deadline to file? If not, litigation may no longer be an option. Good time management means more than just fitting court dates into your calendar. It means making sure the law itself is on your side. Number 4, think through the end game, the best and worst case scenarios. It's easy to get caught up in the idea of winning, but smart litigants think several moves ahead. Before you file, sit down and think through every possible outcomes. What's the best that could happen? It could be that you win your claim and recover everything you've asked for. What's the worst? It could mean that you lose and end up paying the other side's legal fees. What's the most likely outcome? A settlement somewhere in the middle. Could the other side have a cross-claim against you? What happens if you win on principle but spend more money than you recover? What happens if you win but the other side goes bankrupt and all creditors line up to get their money? It isn't about scaring you, it's about preparing you. Litigation isn't just a legal process, it's a strategic one. Thinking through the end game prevents nasty surprises later. Number 5, put everything in chronological order. Once you've thought strategically, it's time to get organized. And one of the most powerful things you can do is to build a clear timeline. Start from the very beginning and list every key event in order, with dates, names, and details. Here's why it matters. In one case, my client's timeline exposed a critical pattern the other side was trying to hide. That single detail changed our entire strategy and led to a favorable settlement. Lawsuits are stories, and stories are strongest when they're told in order. A clear timeline turns confusions into clarity for you, your lawyer, and eventually the court. And most importantly, it will save you thousands of dollars. Because if you don't do that by yourself, guess what? Your lawyer will do it for you. They will charge hourly rates to put together things that you don't bother to do by yourself. And lawyers will seek your feedbacks and amend them over and over again, which will sometimes double the cost before you know it. A clear, well-documented timeline makes your story easier for your lawyer to present and massively improves efficiency. It also helps you spot gaps in your evidence before they become headaches in court. Number 6. Check and keep all records. Now let's talk about the backbone of any case, evidence. Gather every relevant documents, including contracts, emails, letters, invoices, photos, text messages, and physical items. Store them securely and make digital backups. Label them clearly and organize them by date or topic. And one more crucial tip. Once you believe litigation is likely, stop deleting anything. One of my clients deleted messages sent by her opponent with cursing words because she was so angry. But those communication records were crucial to prove the other side's wrongs. It was a turning point in that case. Destroying evidence, even accidentally, can seriously damage your credibility and your case, so stop doing that. Strong records build strong case. Weak records lead to weak results. Number 7. Make a final attempt at negotiation. Before you file any pleadings, ask yourself this: have I truly tried everything else? Here's why. Based on my personal experience, 70% of the time, my clients send a formal demand letter before filing suit. The other side, not wanting a public legal fight, agreed to pay the entirety or part of the money demanded. No lawsuit, no trial, problem solved. Litigation should always be your last resort. Explore alternatives like settlement discussion involving a third-party mediator or legal representative from both sides. A well-crafted demand letter or structured negotiation often leads to solutions without even stepping into a courtroom. Even if it doesn't work, showing that you tried to resolve the dispute can work in your favor during litigation. And who knows, you might save months of time and thousands of dollars in process. Number 8. Do a health and mental readiness check. This is one that people rarely think about, but it is incredibly important, your well-being. Litigation is stressful. It can take an emotional and physical toll. So before you start, check in with yourself. Are you mentally prepared for a potentially long process? Do you have support from any family and friends? Would it help to speak with a counselor or therapist? What if your psychologist suggests you take caution and not be involved in adversarial exercise? What if your doctor diagnosed that you are terminally sick? These conditions may not only have an impact on your life, relationship with others, and financial position to proceed with the case, it may also change your decision as to whether you should start in the first place. Keep in mind that the litigation process will take years, and if you are stressed, exhausted, or distracted, it can impact how you make decisions and how your case unfolds. Taking care of yourself is not a luxury, it's part of your litigation strategy. Number 9. Check with potential witnesses. Think about who might help support your story in court. Witnesses can make or break a case. Witnesses could be yourself, your family members, your employees, your business partners, and any person that has actual knowledge about the facts of the case. I've assisted a client to have a favorable settlement because we managed to contact the opponent's ex-wife and persuaded her to testify against the opponent. So think about if that could happen to you. Identify them early and reach out before litigation begins. Ask these questions. Are they willing to testify? Do they remember the details clearly? Do they have records or notes of their own? In one case, a witness's recollection shifted dramatically 6 months after the litigation started. If the client had spoken to them earlier, we could have adjusted our approach before trial. Memories fade and people move on. The sooner you contact potential witnesses, the better prepared you will be when the time comes. Number 10. Time your litigation strategically. Finally, let's talk about timing, because when you file can matter almost as much as what you file. One client waited until the end of the supplier's busy season to file. Why? Because the supplier would be more motivated to settle when they had cash flow. It worked, and the case resolved quickly. Sometimes waiting a few weeks or months can strengthen your position. For example, aligning with the business cycle, waiting for a key witness's availability, or filing before the other side makes a major move. Other times, filing sooner gives you the upper hand by controlling the pace and narrative. Pay attention to the regulatory changes, as this may affect your prospect as well. Work with your lawyer to choose the best moment. And as always make sure you file well before any deadlines. Conclusion. And there you have it, 10 essential things you need to do before litigation. Let's recap. Define your goal and understand what a win looks like. Plan your budget. Manage your time and check the statutory limitation period. Think through the best and worst case scenarios. Build a clear timeline. Gather and preserve all records. Make one last attempt to negotiate. Take care of your physical and mental health. Speak to potential witnesses and time your litigation strategically. Do these things, and you are walking to litigation with clarity, confidence, and control instead of stress, chaos, and regret. Lastly, always consult a qualified lawyer about your specific situation. Thanks for watching, and I will see you in the next one.